You cannot study firearms and crime without understanding the legal framework that surrounds them. That framework determines which questions researchers can ask, which policy variations they can study, and which tools policymakers can use. And it has shifted dramatically in just the past 2 decades. Start with the history. Firearms were common in colonial America, but they were also regulated. Colonial governments inventoried weapons, required militia members to maintain them, imposed storage rules, and prohibited ownership by groups they deemed dangerous. The combination of widespread ownership and extensive regulation is the historical reality, even though contemporary debate often treats rights and regulation as opposites. The militia tradition shaped early thinking, and it echoes in the Second Amendment's opening clause about a well-regulated militia. After the Civil War, the 14th Amendment and the Civil Rights Act of 1866 responded in part to Southern black codes that sought to disarm formerly enslaved people, giving the era lasting doctrinal significance. For most of the 20th century, courts read the amendment as a collective right, protecting state militias rather than individual ownership. That reading drew on the brief and ambiguous 1939 decision in United States versus Miller. Beginning in the 1970s, scholars built the case for an individual rights reading, and that work created the conditions for the 2008 decision in District of Columbia versus Heller, written by Justice Scalia, which held that the Second Amendment protects an individual right to keep and bear arms unconnected to militia service. 2 years later, McDonald versus City of Chicago applied that right against the states through the 14th Amendment. Then, in 2022, Bruen reshaped everything. The court rejected the means end balancing that lower courts had used and replaced it with a test grounded purely in text, history, and tradition. Judges who are not historians must now decide whether modern regulations have sufficient historical analogs. The 2024 decision in Rahimi eased some of that uncertainty, upholding the disarmament of people under domestic violence restraining orders and clarifying that an identical historical analog is not required. On the statutory side, federal regulation is layered and cumulative. The National Firearms Act of 1934 taxed and registered machine guns, short-barreled weapons, and silencers. The Gun Control Act of 1968, enacted after a series of assassinations, created the categorical prohibitions on possession that remain at the core of federal law. The Firearm Owners Protection Act of 1986 eased some burdens but included the Hughes Amendment, which froze the supply of civilian machine guns. The Brady Act of 1993 produced the modern background check system operated by the FBI through NICS since 1998. The 1994 assault weapons ban expired in 2004 under a sunset provision. The Bipartisan Safer Communities Act of 2022, passed after Buffalo and Uvalde, made several modest reforms. Federal law sets a floor. States build above it, and the variation is enormous, from restrictive regimes in states like California and New York to permitless carry across much of the South and Mountain West. Within states, preemption laws often prevent cities from regulating more strictly than the state. This structure matters for research. The policy variation that researchers exploit is itself a product of the federal-state system. Policies that are uniform nationwide, like the Gun Control Act prohibitions, cannot be evaluated by cross-state comparison because there is no state without them. And because firearms flow across state lines through the so-called iron pipeline, one state's choices affect crime in another. The legal framework does not just constrain policy, it shapes what we can know.